Welcome to International Trade Minute, quickfire trade news, the essential podcast for today's trade professionals, presented to you by Reidel Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. In today's episode, we're diving into several significant developments. The CIT's latest ruling on Section 301 duties affecting medical supplies, CBP's interesting take on shuffleboard table classifications, potential trade retaliation scenarios under a future Trump administration, and crucial updates on de minimis rulemaking from the Commerce Department. We bring you these updates distilled into straightforward, bite-sized insights, perfect for your morning commute or coffee break. Let's get started with our first story. In a significant ruling, the Court of International Trade has rejected retractable technologies requests for both a temporary restraining order and preliminary injunction to stop the collection of Section 301 duties on their needles and syringes. However, Judge Claire Kelly did grant a suspension of liquidation for the company's entries during the pending litigation. The court's decision hinged primarily on retractable's failure to demonstrate irreparable harm. Despite claims of non-recoverable financial losses and business disruption, the company couldn't provide sufficient evidence that these harms were imminent due to the Section 301 tariffs. The case raises substantial questions about USTR's compliance with APA requirements. Retractable argued that USTR failed to properly conduct notice and comment periods before implementing the duty increase. The government pointed to two comment periods, one in October 2022 as part of the four-year review, and another in May 2024, specifically addressing medical supplies. Notably, out of nearly 1,500 comments in the first period, none specifically referenced syringes or needles. The court found particular merit in Retractable's argument, questioning whether these notices satisfied APA requirements and whether USTR engaged in reasoned decision-making. There's a serious question about whether comments from Retractable's competitors during the supply chain inquiry inappropriately influenced the rate hike. While the legal questions were deemed substantial, the court ultimately sided with the government on the balance of equities. Judge Kelly noted that if Retractable were exempt from paying duties during the case, the government could potentially lose millions if the importer ultimately lost. Instead of completely halting duty collection, the court opted for the more measured approach of suspending liquidation, which preserves both parties' interests while the case proceeds. For trade practitioners, this ruling underscores the high bar for demonstrating irreparable harm in duty collection cases, while also highlighting the continued scrutiny of USTR's administrative procedures in implementing Section 301 tariffs. The case bears watching, as it may set important precedents for future challenges to Section 301 duty increases. In a recent ruling, CBP has determined that shuffleboard tables should be classified under the category for video game consoles and parlor game tables, rather than with chess and backgammon tables. This decision came after global merchants requested reconsideration of a previous classification ruling. The shuffleboard tables in question feature a two-piece wooden cradle supporting the playing surface, where players slide metal pucks lengthwise across a polymer-coated surface marked with scoring zones. CBP maintained its original classification under subheading 9504.90, which covers parlor games and related equipment. Up next, several key factors influenced CBP's decision. Unlike chess and checkers, which are typically portable and often sold as combined sets, shuffleboard tables are substantial pieces of equipment more closely aligned with parlor game furniture. The agency also rejected arguments about the special design of the playing surface, noting that this feature alone doesn't warrant classification with traditional board games. The importer's attempt to draw parallels between shuffleboard tables and furniture pieces featuring chess or checkers playing surfaces also failed to convince CBP. While such combination furniture pieces do fall under the chess table category, shuffleboard tables are fundamentally different in nature and use. For trade practitioners, this ruling clarifies the distinction between traditional board games and larger gaming equipment in customs classification. It also emphasizes that size, portability, and manner of sale are significant factors in determining proper classification for gaming equipment. Moving on to our next story, in significant trade news, advisors are warning that American exporters should brace for potential retaliatory measures from trading partners if proposed tariff increases materialize in the coming year. Former Wisconsin Representative Ron Kind, now with Arnold and Porter, emphasizes that trading partners have been explicit about their intention to respond to any new U.S. tariffs with countermeasures of their own. The agricultural sector appears particularly vulnerable to these potential retaliatory actions. China has already demonstrated its ability to pivot away from U.S. agricultural products with established alternative supply chains through South America, Central America, and Asia Pacific regions, including Australia and New Zealand. Of particular concern is the soybean industry, which exports approximately 70% of its production. Lynn Fisher Fox, a former International Trade Administration official, points out that targeted retaliation against products like soybeans, dairy, and citrus could have severe implications for American farmers. The impact could extend beyond agriculture, potentially affecting U.S. service providers and digital trade companies. There's growing concern about the broader implications of these potential tariff escalations. Trading partners may be better prepared this time around, having learned valuable lessons about effective retaliation targets during previous trade disputes. The situation could force countries to reevaluate their long-term trade relationships with the United States, potentially leading them to seek alternative partnerships. The possibility of a wider tariff war looms large, with implications extending far beyond immediate economic impacts. Any new tariffs implemented could prove difficult to withdraw later, creating lasting changes to global trade patterns and relationships. For trade practitioners, this signals the need for proactive planning and potential supply chain diversification strategies to mitigate future risks. For our concluding piece, looking ahead to significant regulatory changes, the Department of Homeland Security is moving forward with crucial de minimis rulemaking before the end of the current administration. According to Commerce Deputy Assistant Secretary Tyler Beckelman, a notice of proposed rulemaking is expected before January 20th. The proposed changes are substantial, potentially removing goods subject to Section 301 and other special tariffs from de minimis eligibility. Additionally, DHS plans to issue new requirements regarding data collection for de minimis shipments. These measures aim to enhance CBP's capability to identify and intercept illicit shipments within the de minimis stream, both by reducing volume and improving targeting information. In related developments, the textile and apparel sector has seen notable activity, with 6 new products added to the short supply list this year. Western Hemisphere trade relations show promising growth, with CAFTA countries accounting for $13 billion in apparel imports last year, representing 17% of total imports. Looking further ahead, the African Growth and Opportunity Act's future remains uncertain as it approaches its September 2025 expiration. While bipartisan support for AGOA is expected to continue, the program may undergo significant changes, particularly regarding its third country fabric provisions. The implications could be substantial, considering that AGOA apparel imports reached $1.1 billion last year, ranking as the third largest category after petroleum products and automotive sector imports. For trade practitioners, these developments signal the need to prepare for potential shifts in de minimis procedures and to closely monitor evolving trade preferences programs. The changes could significantly impact supply chain strategies and compliance requirements in the coming year. That concludes our roundup of this week's most impactful trade developments. Thanks for tuning in to International Trade Minute. We hope you found today's episode insightful and useful for your practice. Remember, our podcast is brought to you by Reidel Law Firm, your trusted partner in navigating international trade law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.